Welcome everybody. How are you? I am none other than Leonard French, your favorite copyright attorney, here to talk to you about nothing less than the Sally Kim order on Dark Spilver's motion to quash the Watchtower Jehovah's Witness subpoena to Reddit. I did it! Woohoo! Alright, we're out. That's it. We're done. I did it. How is everybody? Let's hear some more of Pretty. Oh, who is Pretty from? Let's find out. Epidemic Sound. It is by Fascion, like fashion, but without an H, like F-A-S-I-O-N. You got it. Yes, I am wearing the Grumpy Cat hat. Very sorry for everyone's loss. Let's get this all straightened back out while you're all filtering in, and we will get started right away because we have 18 pages to go over, but it is chocked full of good stuff. Judge Kim wastes no space, wastes no extra pages. How about that? Will waste none of your time. Oh, and there's a Nico. There's a Nico who had his teeth cleaned today. Wanna come up? Hello. Good boy. They said you're allowed to have a light meal. I don't know if this is a light meal. Oh, do you want treats too? Come here, Ilsa. Up. Come on. Good girl. Good girl. Okay, go lay down. Because we got work to do. We can bring back the dogs later. Alright, so what are we talking about today? Let's bring this up here. This is the DMCA subpoena to Reddit. So first thing to note, this is not a lawsuit. This is under DMCA 512H, I think it is, which allows a copyright plaintiff to send a subpoena through the court system, even though they haven't filed a lawsuit. And the subpoena is to uncover the identity of an alleged infringer. So what has happened here, if you have not been with us so far, what has happened so far is the Jehovah's Witness parent organization Watchtower Bible and Tract Society of Pennsylvania, which according to them oversees the intellectual property of the Jehovah's Witness organization, has sent a subpoena for a Redditor, Dark Spilver, a Redditor's identity, and that subpoena has been opposed by Dark Spilver through the Electronic Frontier Foundation, and now also Reddit has joined, although we haven't seen any, as far as I know, anything written from Reddit. We haven't seen any briefs or anything from Reddit, so they've just joined as like a, hey, we're on this side of things, I guess. So let's jump in and I'll explain along the way. So this is the judge's order. At the end of the controversy over the motion to quash, we have the judge's order. Now before the court is a motion to quash filed by John Doe under his pseudonym, Dark Spilver, having carefully considered the parties' papers, relevant legal authority, the record, etc. We hereby grant in part and deny in part Dark Spilver's motion to quash for the reasons set forth below. Well, that doesn't help us very much. Let's continue. On January 9th, 2019, petitioner Watchtower filed this action to request the court issue a subpoena pursuant to the Digital Millennium Copyright Act to Reddit to discover the identity of Dark Spilver, the Redditor's pseudonym. On January 16th, the clerk issued the subpoena. Watchtower served the subpoena on Reddit January 24th, 2019. It says 2010 here. That's kind of a funny typo. Reddit has not yet provided the identity and has joined the motion to quash in form. They haven't really function, maybe. I don't know. They haven't really filed a brief yet, is what I'm saying. Darkspilver was raised as a Jehovah's Witness and has been a member of that community his whole life. There is a footnote on his. It is unknown whether Darkspilver is male or female, but Darkspilver has chosen the male nom de plume of John Doe. Thus, the court will use male pronouns in this order in referring to Darkspilver. I think that that answers some questions about how aware Judge Sally Kim is, and I'm very grateful to see that. Many of Darkspilver's friends and family members are currently active Jehovah's Witnesses, and Darkspilver considers himself a practicing Jehovah's Witness. Darkspilver states that there are aspects of the organization of Jehovah's Witnesses' teachings and practices that he questions, and that he does not feel as though he can openly discuss his views with other members of the community. He states that different opinions and questions are strongly discouraged. Darkspilver states that in his experience, people who voice their disagreement or doubts face rejection by and disapproval from other members of the Jehovah's Witness community, including leadership and ordinary members. Those who openly disagree with the organization's teachings publicly may be labeled apostates and be excommunicated, and may be excommunicated or disfellowshipped from the community. Other Jehovah's Witnesses, including friends and family members, cut off ordinary social interactions with people who have been disfellowshipped. Darkspilver has personal knowledge of people who, after voicing certain opinions, have been shunned by Jehovah's Witnesses, including people with whom they held close relationships. Reddit is a social media platform. Reddit allows pseudonyms. Darkspilver has participated in a Reddit forum dedicated to self-described former Jehovah's Witnesses. Although Darkspilver does not consider himself a former member, he believes that it is the only place he has been able to discuss and debate matters related to the Jehovah's Witnesses freely and openly. Darkspilver also chose Reddit because of his ability to communicate anonymously on the site. He states that keeping his name and identity private is necessary for him to feel comfortable participating in open discussions about religious teachings and practice. Darkspilver does not live in the United States. According to a map made by participants in the Jehovah's Witness Forum, many of the participants reside in the United States. Watchtower states that as of April 9th, there were 34.1 thousand reported subscribers, an increase from 29,000 in November 2018. Watchtower issues notices of copyright infringement under the DMCA to Darkspilver and to one other subscriber to the Reddit forum. On February 7th, Reddit informed Darkspilver of Watchtower's subpoena. Darkspilver's anonymous posts in the Reddit forum were an advertisement and a chart. Watchtower states that both of these items are copyrighted works. Watchtower states that both of these items are copyrighted works. The advertisement, which was published in a Watchtower magazine, encourages people to make donations to the Jehovah's Witnesses and directs readers to make donations through the website donate.jw.org. Funny, I passed a Jehovah's Witness building today, and jw.org was right there on the outside. So not like anyone doubted that, but like I confirmed that this place exists in real life, right? Darkspilver states that, to his knowledge, both the Watchtower magazine and the advertisement are available for free online. Watchtower published this advertisement online at jw.org and on the back cover of the 32-page November 2018 issue of the Watchtower announcing Jehovah's Kingdom. Darkspilver's stated reason for posting the advertisement on Reddit was to show how openly the organization was petitioning for financial donations from members, to illustrate the organization's use of commercial advertising design, and to point out the organization's encouragement of online donations. All of these represented major changes from the teachings and practices the organizations had espoused in the past. Darkspilver wanted to inform others and spark discussion about the organization's tone, messaging, and fundraising practices. He did not make any money by posting the advertisement on the forum. He posted a screenshot of a chart as well, with information about the personal data the Jehovah's Witness organization stores and processes, along with citations to relevant provisions of the EU's data privacy law called the GDPR, the General Data Protection Regulation. The chart was an internal document that Watchtower did not intend to publicly distribute. Darkspilver created this image by using data in an Excel file that he reformatted to make it more visually appealing and easy to read on a screen. The Excel file that Darkspilver used to create this image is attached as Exhibit D to his declaration. Darkspilver's stated reason for posting the chart on Reddit was to provide information to people in the Jehovah's Witness community about the type of information the organization actually stores and what it does with that information. Darkspilver is aware of concerns that some former Jehovah's Witnesses have with respect to data the organization collects and stores, including records of the number of hours individual witnesses spend doing evangelical outreach and internal handling of many issues, including abuse allegations. Darkspilver concludes, although some people are concerned about data in the organization's possession, I am concerned about excessive deletion of stored information, largely because it might include information about past abuses or the handling of past abuses that might be helpful in the future for discovering or substantiating claims. Excuse me. Darkspilver has serious concerns about Watchtower obtaining his identity. He believes that it would chill his speech and would damage or destroy his relationships with friends and family who remain active members of the Jehovah's Witness community. Darkspilver believes that Watchtower would be able to use the information from Reddit to determine his real identity based on the information the Jehovah's Witnesses have collected about him, including his name and address. Darkspilver explains that he has been part of the Jehovah's Witness community his whole life, and so the pain of social exclusion would be overwhelming. Additionally, if his identity is revealed, Darkspilver would not feel comfortable talking about his experience openly online. Darkspilver would not have shared truthful information or commentary regarding the Jehovah's Witness organization if he knew that his name would be revealed. Darkspilver has already stopped posting on the Jehovah's Witness Reddit forum, and if his identity is disclosed, he will not begin again. In support of his motion, Darkspilver also submits newspaper articles recounting stories from former Jehovah's Witnesses who were shunned or disfellowshipped from the religion. Watchtower submits messages from subscribers to the Reddit forum. After Darkspilver filed this motion to quash the subpoena, some subscribers posted messages stating that their speech would not be chilled by Watchtower, and their efforts to obtain the identity of people they accuse of copyright infringement, but it is unclear if those users are, like Darkspilver, current members of the Jehovah's Witnesses. Watchtower is not Darkspilver's local church and does not have the ability to excommunicate him from his local congregation. Watchtower states that no person who has been subject to a DMCA subpoena has been excommunicated from his or her local church as a result of Watchtower's learning his or her identity, and that Watchtower has not disclosed to the public the names of individuals who were the subjects of DMCA subpoenas. So the judge now gets to the analysis part. That was the factual background. Watchtower contends that the advertisement and the chart are protected by copyright, and that Darkspilver infringed Watchtower's copyright by posting them. Darkspilver counters that his identity is protected by the First Amendment right to free speech, and that his posting of these items were non-infringing fair use. First, Watchtower argues that the court should reject Darkspilver's motion as untimely. However, the authority upon which Watchtower relies applies to parties. Darkspilver is not a party to a lawsuit, and was not even the recipient of the subpoena. Yeah, I think we're messed up here. Darkspilver was not a recipient of the subpoena. According to Watchtower, Darkspilver should have moved to quash before the return date of the subpoena, February 15th, but Darkspilver did not even have notice of the subpoena until February 22nd. Moreover, it is undisputed that Reddit has not responded to the subpoena. Therefore, the court finds that the motion is not untimely and will address the merits of the motion to quash. Then, whether the First Amendment applies. Watchtower disputes that Darkspilver's speech is entitled to any protection under the First Amendment. According to Watchtower, because Darkspilver resides outside the United States, applying the First Amendment to his speech would be an impermissible, extraterritorial application of American law. For support, Watchtower cites two cases, Johnson v. Eistrager and United States v. Verdugo-Urquidez, which are Fourth and Fifth Amendment cases. In Johnson, the Supreme Court held that military prisoners captured abroad were not entitled to the protection of the Fifth Amendment because they were A. enemy aliens, B. never been or resided in the United States, C. were captured outside the U.S., held in military custody as war prisoners, D. were tried and convicted by a military commission outside the U.S. for war crimes committed abroad. Under those circumstances, the Supreme Court rejected the extraterritorial application of the Fifth Amendment. Then, in Verdugo-Urquidez, the Supreme Court noted the nature of the Fourth Amendment. It prohibits unreasonable searches and seizures, and a violation of the amendment is fully accomplished at the time of an unreasonable government intrusion. Therefore, if there were a constitutional violation, it occurred solely in Mexico in that case. In that case, the court rejected the extraterritorial application of the Fourth Amendment to a search conducted in Mexico of a Mexican resident and citizen home. In contrast here, the constitutional right at stake is a different constitutional amendment, the First Amendment, and the asserted violation does not concern merely extraterritorial conduct. The subpoena here was issued by a court in the United States on behalf of a United States company, Watchtower, and was directed against another United States company, Reddit. Moreover, the First Amendment protects the audience as well as the speaker. As another court in this district explained, the First Amendment does protect the public of this country, as Justice Brennan pointed out in A Quality of Copies of Books versus a quantity of copies of books versus the state of Kansas. I guess this is a seizure case. There is a right of the public in a free society to the unobstructed circulation of non-obscene books. The First Amendment surely was designed to protect the rights of readers and distributors of publications no less than those of writers or printers. Indeed, the essence of the First Amendment right to freedom of the press is not so much the right to print as it is the right to read. The right of readers are not to be curtailed because of the geographical origin of the printed materials. In other words, the protections of the First Amendment extend beyond the personal rights of the speaker. The Ninth Circuit explains. The First Amendment interests in this case are not confined to the personal rights of plaintiffs. Freedom of the press was not guaranteed solely to shield persons engaged in newspaper work from unwarranted governmental harassment. The larger purpose was to protect public access to information. Freedom of association was secured not only to protect the privacy of those who assert their rights in litigation, but also to shelter all persons from unjustifiable government prying into their associations with lawful groups. In the context of litigation, vindication of these public rights secured by the First Amendment is primarily committed to persons who are also asserting their individual constitutional rights. Although the exact percentage of subscribers to Reddit's forum who live in the United States is unknown, the only data before the court suggests that a substantial number are United States residents. Based on the involvement of the United States court's procedures by and against United States companies and the audience of United States residents, as well as the broad nature of the First Amendment protections, the court finds that the First Amendment is applicable here. Then, to determine which test. It is well established that the First Amendment protects the right to anonymous speech. Moreover, the protection for anonymous speech applies to speech on the internet. As with other forms of expression, the ability to speak anonymously on the internet promotes the robust exchange of ideas and allows individuals to express themselves freely without fear of economic or official retaliation or concern about social ostracism. The right to speak, whether anonymously or otherwise, is not limited, however, and the degree of scrutiny varies is not unlimited. Let me start that one over. The right to speak, whether anonymously or otherwise, is not unlimited, however, and the degree of scrutiny varies depending on the circumstances and the type of speech at issue. The nature of the speech should always be the driving force in choosing a standard by which to balance the rights of anonymous speakers in discovery disputes. Courts apply a rigorous or most exacting standard when the speech is political, religious, or literary. In contrast, commercial speech is afforded less protection. where here the speech touches on a matter of public interest, courts in this district have applied a stronger standard than if the speech were commercial. And this is where the Highfields Capital Management versus Doe case comes in. In Highfields, the speech at issue was postings of a sardonic commentary on a public corporation through irony and parody. These bulletin board postings expressed dissatisfaction with the performance of the stock and the way company executives chose to spend company resources. The speech also expressed disapproval or criticism of the corporation's largest single shareholder. The speech expressed views in which other members of the public may well be interested, and that the speaker had held the right to express anonymously. The court noted speakers' rights to speak anonymously on these topics were vulnerable and precarious and close to the central societal values that animate our Constitution. In Art of Living Foundation, the speakers were former students and teachers of the organization, Art of Living Foundation, who anonymously criticized the organization and its leader in an internet blog. The court cited an opinion from the California Court of Appeal for the proposition that although matters of public interest include legislative and government activities, they may also include activities that involve private persons and entities, especially when a large, powerful organization may impact the lives of many individuals. And then there was a Church of Scientology case, allegations that a Church of Scientology or that the Church of Scientology harmed and abused its members. It was speech in connection with a public issue. Considering that the organization had chapters in 140 countries and was one of the United Nations' largest volunteer-based non-governmental organizations, the court held that the speaker's condemnation of the organization was clearly a matter of public interest. Here, Darkspilver anonymously posted to the Reddit forum to comment and foster thoughtful and critical dialogue on the practices of Jehovah's Witnesses. The court finds that Darkspilver's speech was a matter of public interest. Therefore, the court will apply the following two-part test articulated in Highfields and Art of Public Living. 1. The subpoenaing party must produce competent evidence supporting a finding of each fact that is essential to a given cause of action. And 2, if the subpoenaing party makes a sufficient evidentiary showing, the court must compare the magnitude of the harms that would be caused to the competing interests by a ruling in favor of the subpoenaing party and by a ruling in the favor of the anonymous speaker. So evaluating this two-part test. As the court in Highfields explained, under this prong of the test, I guess the first part, the evidentiary basis, the plaintiff must adduce competent evidence, and the evidence plaintiff adduces must address all of the inferences of fact that plaintiff would need to prove in order to prevail under at least one of the causes of action plaintiffs assert. In other words, the evidence that each plaintiff adduces must, if unrebutted, tend to support a finding of each fact that is essential to a given cause of action. The court may not enforce the subpoena if, under plaintiff showing, any essential fact lacks requisite evidentiary support. So they have to establish that they have the basics of a case. To establish a prima facie case of copyright infringement, a plaintiff must show ownership of a valid copyright and a violation by the alleged infringer of at least one of the exclusive rights granted to the copyright owners by the Copyright Act. Watchtower argues that it laid out a prima facie case in its subpoena application. However, the application does not actually address the registration of any copyright or otherwise show that either the advertisement or the chart is a copyright-protected work. The application simply states that Darkspilver's posts infringe a copyright held by Watchtower and cite to the declaration of Attorney Polidoro in support of the subpoena application. The declaration does not address the copyright protections of either the advertisement or the chart. In the declaration in support of its opposition to the motion to quash, Mr. Polidoro states, Watchtower is the copyright owner of both the advertisement and the chart. This brief statement is the full extent of Watchtower's evidence in support of its claim that it owns a valid copyright in the record before the court. On to the advertisement. Darkspilver does not contest that Watchtower registered the publication in which the advertisement was included, the magazine, and thus does not contest copyright ownership for the advertisement. A certificate of registration from the U.S. Copyright Office raises a presumption of copyright validity and ownership. Therefore, for purposes of this motion, the court will assume that the advertisement is part of a registered work. Moreover, Darkspilver does not contest that he posted copies of the advertisement on the Reddit forum. Therefore, the court finds that Watchtower has demonstrated a prima facie case of copyright infringement for the advertisement. Darkspilver argues that Watchtower has not made a sufficient showing because his posting fell under fair use. However, Darkspilver bears the burden to prove the defense of fair use. Therefore, Watchtower does not need to counter this defense in order to demonstrate a prima facie case of copyright infringement. Therefore, the court finds that Watchtower has met its showing under the first prong of the advertisement. As to the advertisement. And then there's a footnote here. Although fair use is not a traditional affirmative defense, the burden of proving fair use is always on the putative infringer, according to Lens v. Universal. The chart. It is not clear that the chart meets the minimum standard of originality required for copyright protection. Yay! That's what we said. Watchtower has not registered the chart. The chart is not entitled to a presumption of copyright validity, and Watchtower must submit evidence to make the requisite showing. In Victor Lally Enterprises versus Big Red Apple, a 1991 Second Circuit case, the court held that a chart did not merit copyright protection because it was merely a compilation of pre-existing facts. Although a compilation of facts could meet a minimum for copyright protection if it features original selection, coordination, arrangement, the court found that the plaintiff's compilation failed to meet this requirement. Although novelty is not required, some modicum of creativity is necessary to transform a simple compilation into copyrightable expression. The court held that the charts were not entitled to copyright protection because the format of the charts lacked selectivity that the charts lacked selectivity in what was reported and how it was reported. Here, Watchtower summarily argues that the layout, design, and word choice of the chart are all creative in nature with no supporting evidence. In the absence of any supporting evidence, the court finds that Watchtower has not met its burden to show with competent evidence its ownership of a valid copyright in the chart. Therefore, Watchtower fails to demonstrate a prima facie case of copyright infringement with respect to the chart. Because the court finds that Watchtower demonstrates a prima facie case of copyright infringement with respect to the advertisement, the court will then address the second prong, the magnitude of the harms, comparing a ruling in favor of Watchtower to a ruling in favor of Darkspilver. Darkspilver presents evidence to show that revealing his identity to Watchtower would chill his speech on the Reddit forum. He selected that forum because it was a place where he could communicate anonymously with other current and former Jehovah's Witnesses. He is concerned that if Watchtower discovers his identity, the revelation of his identity would damage or destroy his relationships with friends or family who are active members of the Jehovah's Witness community. Speaking anonymously is necessary for him to feel comfortable participating in open discussions about religious teachings and practice. Darkspilver has already stopped posting on Reddit and will not begin again if his identity is revealed. Watchtower disputes Darkspilver's assertion that his free speech will be chilled by citing to statements made by other individuals. Considering that this is a forum for former Jehovah's Witnesses, people who have already left the organization and presumably the community, it is not surprising that some express that they would not be deterred from speaking if their identities were revealed. But selecting quotes from others does not undermine Darkspilver's expressed concern over speaking openly about his views on Jehovah's Witnesses practices. Moreover, to the extent other current Jehovah's Witnesses are publishing anonymous posts on Reddit, they also might have concerns. Watchtower further argues that Watchtower is not Darkspilver's local church and has no ability to excommunicate him from his local congregation. Nevertheless, Darkspilver has expressed substantial concerns over having his identity revealed to anyone in the Jehovah's Witness community. The court finds that Darkspilver has demonstrated significant harms if his identity were revealed publicly, or even if it were revealed to Jehovah's Witnesses in his congregation. On the other hand, if Watchtower cannot determine Darkspilver's identity, Watchtower would lose its ability to enforce its copyright. However, in evaluating the balance of harms, the court finds that it should address Darkspilver's defense of fair use. As the Ninth Circuit has made clear, although Darkspilver bears the burden of demonstrating fair use, for purposes of the DMCA, fair use is uniquely situated in copyright law so as to be treated differently from traditional affirmative defenses. Fair use is authorized by law, and that's citing to Lentz. Fair use is not just excused by the law, it is wholly authorized by the law. Moreover, because fair use is a non-infringing use authorized by the law, a copyright holder must consider the existence of fair use before issuing a takedown notification under the DMCA, which is required before obtaining a subpoena. If Darkspilver's posting of the advertisement was fair use, then it was not infringing and Watchtower suffered no harm. Moreover, the fair use doctrine is also relevant because Darkspilver is asserting a First Amendment right to comment on the advertisement. As the court in Art of Public Living explained, while copyright infringement is not protected by the First Amendment, copyright law contains built-in First Amendment accommodations. Of those protections or accommodations of the First Amendment, perhaps the most important is the doctrine of fair use, which allows the public to use copyrighted works for purposes such as criticism, comment, news reporting, teaching, and scholarship. The fair use exception excludes from copyright restrictions certain works, such as those that criticize and comment on another work. To determine whether a work constitutes fair use, courts engage in a case-by-case analysis and a flexible balancing of relevant factors. The four factors are the purpose and character of the use, including whether such use is commercial or nonprofit or educational, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and for the effect of the use upon the potential market or value of the original. The factors are to be explored, and the results weighed together in light of the purposes of copyright. Fair use is a mixed question of fact and law. The first factor, purpose and character of the use, considers the purpose for using the work. Section 107 provides that use of copyrighted materials for purposes such as criticism, scholarship, or research is not an infringement of copyright. This factor considers whether using the work was transformative, that is, whether it adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. The central inquiry under the first factor is whether the new work is transformative. Although not conclusive, the first factor also requires that the commercial or non-profit character of an activity be weighed. Non-commercial, non-profit activity is presumptively fair. Here, Darkspilver's use was non-commercial, therefore his use was presumptively fair. Moreover, his stated purpose was to evoke conversation about the Jehovah's Witness funding methods or fundraising methods. He wanted to show excuse me. Let me take a sip here. Thank you. He wanted to show openly the organization, He wanted to show how openly the organization was petitioning for financial donations from members to illustrate the organization's use of commercial advertising design and to point out the organization's encouragement of online donations. According to Darkspilver, these fundraising methods were a major change from the teachings and practices from the Jehovah's Witnesses that Jehovah's Witnesses had espoused in the past. He posted the advertisement to inform others and spark discussion about the organization's tone, messaging, and fundraising practices. Watchtower does not challenge this motivation. Posting copyrighted material for criticism or to spark conversation about it are purposes that the Fair Use Statute authorizes. On the other hand, Darkspilver did not alter or strongly transform the advertisement. He posted it in full with the caption, "What gift can we give to Jehovah? Guess what?" Full back page advert from WT Magazine, November 2018. There is no factual dispute about the posting. However, because of the non-profit nature of Darkspilver's posting and his stated purpose to evoke conversation, the court finds that this factor weighs in favor of Darkspilver. On to the second factor, the nature of the copyrighted work. The second factor recognizes that creative works are closer to the core of intended copyright protection than informational and functional works. Whether or not a work is published is critical to its nature under Factor 2. The scope of fair use is broader for published works. Thus, even substantial quotations might qualify as fair use in a review of a published work. Here, the advertisement was published in November of 2018. Moreover, the advertisement was largely informational and functional, directing readers how to make donations online. This factor weighs in favor of Darkspilver. The third factor asks whether the amount and substantiality of the portion used in relation to the copyrighted work as a whole are reasonable in relation to the purpose of the copying. This factor has both a quantitative and a qualitative component, so that courts have found that use was not fair where the quoted material formed a substantial percentage of the copyrighted work, or where the quoted material was essentially the heart of the copyrighted work. Here, even though Darkspilver copied the entire advertisement, it was only a small portion of the copyrighted work as a whole, a 32-page November 2018 Watchtower magazine. The advertisement was on the last page of the magazine. There is no factual dispute about this issue, nor was the advertisement qualitatively the heart of the published magazine, which was full of articles discussing matters of faith for Jehovah's Witnesses. In contrast, the advertisement described how to make online donations to the organization. Effect of the use on the potential market, or the market usurpation factor. The fourth factor asks whether actual market harm resulted from the defendant's use of plaintiff's protected material and whether unrestricted and widespread conduct of the sort engaged in by defendant would result in a substantially adverse impact on the potential market for the original or its derivatives. A use that has no demonstrable effect upon the potential market for the value of the copyrighted work need not be prohibited in order to protect the author's incentive to create. Therefore, what is necessary is a showing by a preponderance of the evidence that some meaningful likelihood of future market harm exists. If the intended use is for commercial gain, the likelihood may be presumed, but if it is for non-commercial purposes, that likelihood must be demonstrated. Watchtower has not demonstrated any actual harm or likelihood of future harm. It argued generally at the hearing that the harm it suffered from people infringing on its copyrights was directing others away from its website. However, the advertisement that Darkspilver posted directs people to visit the website to make a donation. Nevertheless, Watchtower has not yet had a chance to conduct discovery on its copyright claim or to engage an expert to conduct a market analysis. Perhaps Watchtower, if provided the opportunity, could demonstrate that fewer people visited its website after Darkspilver's posting. The court is hesitant, therefore, to deprive Watchtower of the opportunity to develop its claim and supporting evidence before it has even filed suit. In balancing the harms while considering the fair use defense, the court finds that they tip sharply in Darkspilver's favor. However, the court notes that Darkspilver's concerns stem largely out of fear that those in his congregation will discover his identity and shun him. If Reddit reveals Darkspilver's identity to Watchtower's counsel under an attorney's eyes only restriction, then any harm to Darkspilver would be alleviated. This restriction would enable Watchtower to pursue its copyright claim without causing any harm to Darkspilver. Therefore, The court hereby grants in part and denies in part Darkspilver's motion to quash. Reddit shall respond to the subpoena and provide the requested information to Watchtower's counsel. However, only attorneys of record in this matter may obtain information about Darkspilver's identity. Watchtower's attorneys of record shall not disclose Darkspilver's identity to anyone else without approval in a court order from this court. For example, Watchtower's attorneys of record may not disclose Darkspilver's identity even to its client, its staff, its expert witnesses, without further approval in a court order from this court. And there's a footnote. Watchtower claimed at the hearing that it plans to disclose Darkspilver's identity to its forensic experts so that Watchtower can determine how Darkspilver obtained confidential information in the chart and prevent further disclosure of that confidential information. This purpose is not related at all to a copyright issue, and for that reason, the court rejects that form of disclosure. If Watchtower elects to file a lawsuit against Darkspilver, the court directs Watchtower to seek to file the suit under his pseudonym and to keep his actual identity under seal for attorneys' eyes only. Moreover, Watchtower is admonished that any violation of this order will be sanctioned and that this court retains jurisdiction over any potential violation of this order. It is so ordered. May 17th, 2019, Judge Sally Kim, United States Magistrate Judge. What do you think of that? So it turns out that the attorney's eyes only foreshadowing that Judge Kim made in the opening of the oral arguments was in fact where she was leaning on going. And although I don't like it because I automatically want like a 100% win for Darkspilver in this case, I see what the judge is trying to do here. We're at the very initial stages of a case, and there's no reason to throw out Watchtower's entire case just because of this little issue about the identity. However, she sees through the veil of copyright infringement that's being used to really uncover the substance of the identity underneath. So she sees through that veil and says, fine, if you really want to pursue copyright infringement, here, you have all the ways to pursue copyright infringement. You just can't have Darkspilver's name disclosed beyond Attorney Polidoro or whoever is, in the case there. If you're not an attorney of record, you can't have the name. Now, does this mean that is this a physical barrier? No, this is not a physical barrier. This is not any sort of, this is an honesty barrier. This is a trust system. However, Attorney Polidoro is a licensed attorney. He would be putting his career on the line. He would be sanctioned, he'd be held in contempt, and you'd bet that the case would be cited every time that a judge went out on a limb like this for a plaintiff organization that seemed to be misusing copyright like this in order to identify a mole. So that's what seems to be going on here. They seem to be using an allegation of copyright infringement, a very thin, tenuous allegation of copyright infringement, to uncover a mole or person who's leaking confidential information. That's not what copyright's supposed to be used for. Copyright is to promote the sciences and the useful arts by securing to their authors for certain periods of time the exclusive right to certain rights. We call them the copyrights, to distribute, to publish, to display, to perform, to create derivatives, to control derivatives, etc. That's the incentive of copyright, not to find moles. Nowhere in there was copyright's purpose to find leaks of information within your organization. That's clever that you're trying to use it that way. I'll give it marks for clever, but not for ethics and professionalism, Attorney Polidoro. Anyway, that's our show. Let me know if you have questions, although we're not really set up for that, are we? Yeah, so what are the actual consequences if the attorney gives Darkspilver's identity? The judge would hold them in contempt, or be either impose some sort of sanction or contempt. I've never been entirely clear when a sanction is appropriate versus contempt and what the difference is there. But contempt would be the contempt of a court order. But in this case, the judge said that they're going to impose sanctions, which would be the same thing because it's contempt of a court order either way. So in this case, they're the same thing. They probably a monetary fine. This is a difficult one because the injury to Darkspilver would be irreparable. It's not like any amount of money or any court order can force his family and friends that are in the Jehovah's Witness organization to reassociate with him or her. In other words, the First Amendment applies there too in the opposite direction. If I was a judge, or in this case, Judge Sally Kim is a judge, she can't order, even if Darkspilver's family and friends and Darkspilver were in the United States, in her jurisdiction, standing in front of her in the courtroom, she has no power to order them to make up and be friends again. So that's the irreparable harm, and that's why she's trying to balance this. It would be easy to say, well, anytime we have a defendant who says, well, I have a family and friends who will disown me if they find out about this, that they can just get away with copyright infringement. No, so we don't want that. We don't want that result. And she's not saying that's what Darkspilver is doing here, but that's sort of like the hypothetical or theoretical result of a ruling that doesn't allow Watchtower doesn't allow Watchtower to move forward. And the only way Watchtower can move forward is if they get the identity. So she has to give them the identity. Well, the only way that she could give them the identity, or one of the only ways that she can give them the identity and limit the distribution of identity, is attorney's eyes only. So all information regarding the identity is considered confidential. All identity confidential information is now attorney's eyes only, which means only the Reddit attorney, Joe Gratz, only Alexandra Moss from EFF and whoever else has entered there, and only attorney Polidoro from Watchtower gets it. And none of them can distribute it. They can't give it to you or me. They can't share it with their clients. They can only use it for whatever purpose of copyright infringement. So they can use it to serve the person or something like that. And we already know that the EFF will accept service, so that's not even the issue. We don't actually know why we need Darkspilver's identity in order to pursue the copyright claim. But at least Watchtower can't complain about it anymore. And you saw at the end there, the judge saw through the confidential information thing and even made a footnote telling the entire world, like, look, I see this, and I'm not going to allow them to get away with this. This isn't the purpose of copyright. So, yeah, is there a way that they could violate the spirit of the judge's order? Yeah, possibly, but I don't think it's going to work out well for any future litigation of theirs that involves anyone's identity if this very first time, according to them, that they're doing this openly in court like this, that they break the judge's order. So I'm going to pause short of accusing Attorney Polidoro of any misconduct until he actually, hypothetically right now, does. This order just came down. I doubt that Reddit has released the identity yet. It'll probably be Monday or something like that. Maybe someone's appealing this order. I doubt it. There's a non-zero chance, but I doubt that this is going to be appealed. Might be appealed by Watchtower, if anybody, but the order is well thought out. It says it better than I could say it, of course, because she's a very experienced judge, but it says even more than I originally had hoped for it to say. It really goes into great detail, which is why I wanted to bring it to you and share. So what do you think of that? Who would be held accountable if the name gets leaked? Well, the leak would have to be traced back to somebody. That person would be held accountable. Ultimately, I think it would be Attorney Polidoro that would be held accountable if the leak came through him or through his organization. However, you'll notice clever things happen, like a leak will happen and, someone will, oh, well, we didn't, mean to have the password reset go through the old email address, and we didn't realize that someone at the old email address had access, and we changed the password on that, but it wasn't fast enough, and it'll look like they did a really good job, preventing the information from being leaked, but it got out anyway. So how do you blame them? How do you punish them? So we don't really want that to happen, and that's the scenario that we're all concerned about. So I don't want to invalidate. Your concerns are quite valid, that the information about Darkspilver's identity would be leaked or would be given beyond just Attorney's eyes only. So obviously there's going to be lots of thoughts about that. I don't have a lot to say about that. If there's a leak, it'll have to be brought up in court. The judge will hear about it. There'll be a big investigation. And then the judge will issue sanctions. Those sanctions could be monetary. Those sanctions could be jail time. Since it implicates the honesty of an officer of the court, a licensed attorney, that attorney could be disciplined, could have their law license either reprimanded, suspended, or disbarred, depending upon the egregiousness of the leak. So this is a difficult situation for the judge, as Stephen says there. And that this is the best I think the judge could do. I really don't see another way out of this for the judge. The judge, if the judge just flat out denies, even well reasoned, but denies the copyright or copyright ability of the advertisement, then that's technically something that has to be applied everywhere, right? So what happens the next time somebody does it, but we're on the side of a plaintiff's organization, and we want to get the identity of the infringing organization who we really don't like. Forget who we like and don't like here, and try to just look at the law from the dry perspective, and then you can apply whether you like it or not later. That's really easy to do, but just for a moment you got to disconnect whether you like it or not, and just look at the facts and look at the law and how it operates. So we do want copyright plaintiffs to be able to enforce their rights. It's just this is the least. This is the most tenuous, or the least strong copyright infringement claim that I think I've ever seen that's still survived at this far. Now, we're not even in a lawsuit, so it's not even a motion to dismiss. I bet you this wouldn't even survive a motion to dismiss, but the judge here disagrees. She could have applied the motion to dismiss standard here instead, and I don't. But yeah, if she did that, then copyright plaintiffs would be a weird ruling for future copyright plaintiffs. So that is our show, everyone. Thank you very much for joining me. I am Leonard French, your favorite copyright attorney. We have supporters. We have so many ways you can support our organization. You can support us on patreon.com/ljfrench. You can support us on sponsus.org/u/lawfulmasses. You can support us, on twitch.tv/lawfulmasses, where we have the Sunday show at 10 a.m. You can subscribe there. And pretty soon we'll be turning on the YouTube join button. It's a bit more involved than I thought. I have to be creating emojis and doing, the rewards aren't the same. It's tiers, but then there's also like setup you got to do on YouTube. So we'll get that there. So don't forget to like and subscribe, because we have to say that because you guys don't know what to do otherwise. Jeez. So thank you very much to our current supporters for May 2019 at the $50 level. Thank you to John Steele, Gavin, Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael, Pearce, Terry, Chris, Richard, Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Snorre, Wisotzky, allquixotic, and Aspernari. There are so many of you. Thank you all so very much. Let's bring a dog up here. He hears how excited my voice is. Thank you also to the $5 plus supporters who are scrolling on the LED panel back there. And will be on, I think you're already in the description. Hey, come. And there's our puppy with Nico with his clean teeth. Nico with his clean teeth. Look at him. Look at him. He's such a good dog. Oh, do we have another good dog? Does good dog want to come hop? You know, just because you're old doesn't mean you can't come hop. No. Off. Ilsa, hop. Hop. Come on. Go girl. Go girl. So thank you very much for joining me. I did not take a great look at super chats. Let's see here. Open a new window. Thank you to our one super chat from -74. Really appreciate ya. I'll play the piano for you someday, asks NATO. So everybody have a great weekend. Hope you enjoyed that stream. Hope that helped you understand the whole copyright law, fair use, and how it applied to this case, because we had been discussing it, but now just like a month later you get to see how a court actually rules on it. So I thought that was pretty cool, and I wanted to share it with you because I love you all, my lawful masses, and I am Leonard French, your favorite copyright attorney, yours truly, sincerely, and of course don't forget the 2 dogs. All right, love you, bye.